gives me great pleasure to welcome the speakers to this panel, and I would briefly introduce them. They all have illustrious CVs, and I don't want to spend time doing that. Knowing that, I just want to highlight a few of the things that they are, that amongst their many accomplishments. So first, to my left is Peter Barnett. Peter is program lead at Quadrature Climate Foundation, where he helps direct science-led investments to unlock critical climate solutions, specifically focusing on the role that law and finance plays in accelerating climate action. Pete is also a visiting researcher at the Asia Pacific Center for Environmental Law and the E.W. Barker Center for Law and Business at the National University of Singapore. Prior to joining Quadrature, Pete was Associate Director for Japan and Southeast Asia at Climb Earth, leading a team of law and policy experts to working collaboratively to address climate change. And in previous roles at Climb Earth, he led corporate climate litigation in Europe, with his work featured in the Financial Times, The Economist, and other leading media outlets. And next to Pete is Mr. Rajiv Lai. Sorry, I should not say Mr. Rajiv Lai, Dr. Lai. Sorry. Dr. Lai, I'm very glad you're able to join us here today. Dr. Lai is a veteran economist and business leader. Over his diverse career, Dr. Lai has straddled leadership roles both in business and in public policy. He was the founder, managing director, and CEO of IDFC Bank and the executive chairman of IDFC Limited. Prior to this, he was a partner with Warburg Pincus, New York, and also head of Asian Economic Research with Morgan Stanley in Hong Kong, and economist at the World Bank in Washington, D.C., and the ADB, the Asian Development Bank. Dr. Rajiv Lai has served on numerous committees of the Government of India and the Reserve Bank of India, and was India's representative at the G20 Working Group on Infrastructure. Currently, Dr. Lai is a professorial research fellow at the Singapore Management University, where he serves on the management committee of the Singapore Green Finance Center. And next to Dr. Lai is the Right Honourable Lord Carnworth of Notting Hill. I love that title, Lord Carnworth. Lord Carnworth is a former justice of the UK Supreme Court from April 2012 till March 2020. Lord Carnworth was chairman of the Law Commission for England and Wales from 1999 to 2002, and from 1970 to 1994, Lord Carnworth was a practicing barrister, where his main area of practice included planning and environmental law. He is currently a visiting professor in practice at the Grantham Institute at the London School of Economics, and since 2004 has worked as an advisor to the United Nations Environment Programme on judicial training, and is a member of their International Advisory Council on Environmental Justice. And next to Lord Carnworth is a dear friend and colleague, Sean Zhang. Sean is Senior Legal Counsel responsible for sustainability at Shein, an online fashion retailer who most of us would be familiar with. And his prior experience includes being a legal consultant for the International Environmental Law Organization, Climb Earth, as well as being in private practice at Allen & Glad Hill. Sean is also an adjunct senior research fellow at the Asia Pacific Center of Environmental Law, where I have the pleasure of working with him, and is the course convener for the Faculty of Law's undergraduate program on environmental law. Sean's area of research focuses on the intersection between climate change and corporate law, and trying to uncover the legal tools and mechanisms that can drive greater corporate action. And finally, but not least, is a dear friend of mine, Dr. Joanna Setzer. Joanna is Associate professorial research fellow at the Grantham Institute at the London School of Economics. Her main areas of expertise are climate litigation and global environmental governance. Her greatest claim to fame for most of us working in climate litigation is that since 2013, she has been involved, and since 2020, she leads the Grantham Research Institute's Climate Change Laws of the World project. It is the most comprehensive global resource on climate policy and legislation. And those of us who depend on this database almost daily, we are indebted to Joanna Setzer. Dr. Setzer served as a contributing author for Working Group 3 of the IPCC 6 Assessment Report, and regularly advises a range of international NGOs, governments, and civil society. So, we clearly have a very distinguished panel today to discuss the topic of corporate climate litigation. And what I will do is to kick off with a question for Joanna. And the reason I'm asking this question is to kind of give a bit of context drawing from the work that you've done on the Grantham Institute's reports annually. And the first question is, who are the people involved in corporate climate litigation today? And what is the impact that is being sought from these cases? I think another way of asking this question is also perhaps to ask whether the kind of actors that you see involved in corporate climate litigation are different from those that have been involved in other areas of climate litigation, for example, in those constitutional challenges for government action or inaction on climate change. So over to you, Joanna.
Thank you. Thank you, Jolene, and hello, everyone. It's great to be here. Thank you so much for this invitation. I also love Singapore, and it's wonderful to have this opportunity to come and be here in person. So, Jolene asked me to speak about who's involved, and maybe a bit about the impacts of corporate litigation. And the way I will go about in answering this question is, first, I want to give some context of where this sits. Then secondly, I want to talk about who is being targeted by this type of litigation. And thirdly, who's bringing these cases. So all very brief. I might get also to the impacts. So putting in context, I think it's important to keep in mind that despite a lot of attention that litigation against corporations receives, this is the minority of what we know as climate litigation. So roughly, it's 70% of cases against governments and much less against corporations and individuals. So small number of cases, but that get a lot of attention from the media, from academics, etc. Now, when we think who these cases are being brought against, the first and most obvious set of actors were the major carbon emitters, particularly the oil companies. Now, we are seeing, and this is very much what we observed in our last two reports, we're seeing a diversification of actors involved in this litigation, which is very interesting. I had that sense, but then not until we counted and assigned sectors to each cases that we had that clear vision. In the report, we called it the rainbow graph chart, because we start in 2015 with litigation against corporates, so it's basically oil and gas, cement, oil and gas, cement. And then as you start moving, and especially these last 2 years, the bar becomes multicolored. So you start seeing all different sectors, from textiles, car manufacturers, fashion industry, the financial sector, banks, insurance companies, and agriculture, food, beverages. So this is also something that I think it's very interesting to see, is this diversification, particularly in the recent years that we have observed. And just the last point in this types of actors, we also saw this last year cases brought against professional services, so a case that is brought by a subnational government in the US against the oil majors, but also against McKinsey. Looking at the role that this professional services might have in this in this case with extreme weather events, but how they advised and fraud to the public. So this was the second point. So diversification of corporates. So we can't think about just corporates in general. Now we can think about many different types of corporates. And thirdly, who is bringing these cases? So Jolene asked, is it the same as the litigation against governments, same sets of actors bringing these cases? And I would say it's not. Of course, there are some that are in common, but there's some differentiation. So looking at who has been filing cases against corporations, of course, the first, most obvious ones are the NGOs. They are the most visible, the most loud, I would say. And therefore, we tend to talk a lot about the cases brought by Client Earth or Milieu Défensif, Friends of the Earth, Greenpeace, and so on. And I think there's something interesting to think about this loud aspect, because what I mean there is that litigation is one part of a broader strategy that these NGOs have. So they could be gluing themselves to chimneys or putting a ship out in the Arctic, and on top of that, they bring a case, but the case speaks to that broader strategy. And of course, it comes with a communication, media outreach that makes those cases quite visible. They have achieved already some successes, and of course, we already spoke here several times today about the Milieu Défensif case versus Shell in the Netherlands, and in less than a month, we'll have the decision by the Court of Appeals, so let's see what happens there. But, of course, these are not just the only ones bringing cases against corporates. So the second group would be individuals and communities that are affected by climate change. And if we think about the compensation claims, there are a few quite high-profile ones too. So you would have heard about Saul Luciano Liuya, the Peruvian farmer who files a case against RWE in Germany. But then this last year, there was a new case filed by another individual against a multinational corporation. This is Hughes File. I don't know how to pronounce files or something. Falis. Apologies, Falis, I think it's said, in Belgium against Total. So this is a farmer who says, well, I'm being affected by the production of my farm is being affected by climate change, and files a case against Total. So you have these individuals filing compensation claims or communities filing also claims against corporations. I think it's important now to, as I finish who's bringing the cases, to talk about two groups that sometimes we tend not to look so much, but they are crucial in corporate litigation. First, the public prosecutors. So many countries have public prosecutors who one of functions is to defend, protect, and enforce environmental law. So countries such as Brazil, Mexico, Peru, but also in China, have an important role traditionally in enforcing environmental law, and more recently started being involved in climate litigation. So in Brazil, for instance, which is the fourth country in terms of number of litigation now, there are more than 80 cases. The majority of cases have been brought by public prosecutors. And then just kind of still in this kind of more state level, of course, there are governments themselves and subnational governments, as we see in the US with all different states and counties filing cases against corporations. The last group is one that I think we'll speak more in this panel, which is the shareholders and investors. So I won't go into detail there, but when there is the idea that there is a mismanagement of climate risks, we are seeing cases which are very interesting because they are brought sometimes from within the company, and I think that's the last interesting angle, which again I'm sure we're going to cover here. So to finish, in terms of impacts and what these cases are seeking, the way I like to see it's not to separate too much according to area of law. Of course, a lawyer would do that, the doctrine, or like some very specific legal principle, but I like to understand these cases in terms of a big picture of cases that altogether are seeking reduction of emissions, financial accountability sometimes and compensation, disclosure, better planning, better processes, as we were speaking before. So each one will address part of this or more than one of these angles. And altogether, what I see is that there is already an impact of this litigation, or the risk of litigation also has an impact, which is a whole story that we can talk more about, in creating action and potentially changing behaviors in corporations. So there's much more to talk, but I will stop here and to the next
Thank you,
round.
Joanna. That was really helpful in painting the landscape for us. And I will definitely love to come back to you to ask you to elaborate a little bit more about the Brazilian cases, particularly those which have been pursued by the public prosecutors against companies for deforestation, because there is a very interesting parallel with some of the cases that have been brought in Southeast Asia. And I think there'll be some very interesting lessons that we could perhaps learn from the Brazilian experience. And also, I think what's really interesting that I would like to kind of also draw on your presentation, what you've just shared, is that what you talk about, how when we talk about litigation, the impacts, we have to also remember that, as you mentioned, for several of the litigants, the litigation is part of a broader advocacy strategy. So when we talk about the effects, I mean, we have the direct effects, where it's a win in the courtroom, and hopefully that win in the courtroom is actually enforced, and then we get long-term change. But there's also the indirect effects, which is, for example, the signaling to other actors in the ecosystem, and also putting the spotlight on companies as well as other stakeholders' performance when it comes to climate change. So thank you very much for that. And I would like to now invite Lord Carnworth to share with us some thoughts about this particular case that has been in the spotlight for quite a bit. And I would like to pick up on this case because we heard this morning about directors' duties in the context of climate change. And as a very high-profile case on this issue has been one, Klein Earth and Shell. And Lord Carnworth, I would like to invite you to share some of your reflections about this case. What does the case outcome suggest about the use of directors' duties in litigation to advance corporate climate accountability? And over to you, Lord Carnworth. Thank you.
Yes, so thank you, Jolene, and thank you to the organisers of this excellent conference. Indeed, I learnt a lot from the first session of the excellent introductory lecture we had from the judge, and then the next session talking about directors' duties, which in a way lead on to this particular case. You say it's high profile. I don't think it was particularly high profile, but it still seems to have acquired a certain general interest because there have been so few cases of that type. I have enormous admiration for Klein Earth. I've done quite a lot of work with them since I had a big case which they brought in the Supreme Court in which I gave the lead judgment about air pollution. And after that, I got to know some of the people involved in it when I was no longer directly involved in the case. And since I retired 4 years ago, I've actually done quite a lot with them. And that particular case, I think the facts of it were known. Genuinely, I needn't go into those, but basically it was a derivative action brought by them as shareholders of Shell, claiming that the board had failed to implement the stated objective of reaching net zero by 2050 and didn't have any credible policies to achieve that. And it was brought as an action under the provisions of the Companies Act, which allow that to be done. They actually came to see me after they'd lost in the first court. The first judge, as was explained this morning, I think, had thrown the case out as not really arguable, so it didn't even get beyond the first stage of leave. And they had then gone to the Court of Appeal asking for permission. And at the first stage in the Court of Appeal, the case is heard by a single judge who can throw it out on the papers, and if that happens, that's the end of the case. Or the judge can refer it to a panel to consider whether to grant leave. When they came to see me, it had got to the stage that they were waiting for the first judge's decision. And I looked at it and I thought it was really an interesting case, and certainly if I had been the judge, I would have granted it leave. But as luck had it, the following day they got a decision saying that it was thrown out. Now, I was slightly embarrassed because I had said, well, I'm sure you got a pretty good chance of getting leave at least. And the following day I was proved wrong. And so I thought, well, perhaps I ought to write something about it. And I wrote an article which was published on the website of the Grantham Institute, in which I was quite critical of the judgment in a way that now I'm a retired judge, I'm allowed to do. If I'd been still serving, of course, it would have been quite inappropriate, but it's one of the privileges of being a retired judge that you can say what you like, really. And it seemed to me that the judge had really missed the point of the case. I mean, it was brought under our Companies Act. There is a section which requires the directors to have regard to the interests of the community and the environment. I was interested to hear this morning from Shyam Devan that there's a provision in the more recent Indian Companies Act which actually a little bit more positive than that. It doesn't just require them to have regard to it, actually requires them to take decisions for the environment. But ours just says have regard to. And it seemed to me that what the case was about really was whether the directors had given effect to that duty. They had decided on a policy of net zero by 2050, which was clearly considered by them to be for the benefit of the company and in line with its best interests. But what they hadn't done was actually to produce, as far as the public record showed, any real credible policies to achieve that. And it seemed to me that that at least was deserved a hearing in the court, because of course if it was thrown out at the leave stage, then one never really heard what Shell were saying were their policies for achieving it. Whereas if it had gone to a hearing even on the leave stage, then there would have been a much more disclosure on both sides. So anyway, I wrote an article about that in the Grantham, and it seems to have been picked up rather surprisingly by you and others, I think illustrating the potential, and I'll be very interested to see whether that's carried forward in any litigation elsewhere. My article was hopefully trying to encourage people not to be discouraged. One particular thing I thought was rather odd about the decision was the judge not only said that the case wasn't arguable, because really they were asking the court to sort of substitute themselves for the directors, but they said it was not brought in good faith, which is one of the requirements under the Act, because they said that it was brought with ulterior motives, and undoubtedly client had the motive of pursuing its own agenda, or policy agenda of advancing action against climate change. But, and the judge said, well, that wasn't, that was an ulterior motive as compared to the basic objective of a company of making money for its shareholders. But I found that a bit odd, because given that the company had accepted or decided indeed that it was in the best interest of the company to achieve net zero by 2050, and that was not just a matter of being nice to the community, but actually realizing that it was important for the company to diversify as the market moved out of fossil fuels. Having decided that was in the best interest of the company, then Client Earth's motives were exactly the same. There was no difference between the motives of Client Earth and the motives which the company should have had. So that was the point I made in the article, and it's been interesting hearing people's reactions to that. So, I mean, that's enough, I think, to give you a flavour of the case and my thoughts about it.
Thank you very much, Lord Conworth. Could I just press you to tell us, what do you think, given that leave was denied, and it was, I suppose, as you said, it was only high profile simply because it was seen widely as a test case. a test case in the sense that, not to the best of our knowledge, there has not been a case where directors have been sued for their breach of their fiduciary duties, for their failure to account for climate risks. So what do you think this case outcome suggests? Or do you think that's just too early to say with, just this one case, and the broader message should be, we shouldn't be discouraged?
I don't know. I think wait and see. I mean, I think that undoubtedly that case would be discouraging for others trying to do the same thing, not least because the judge made an award of costs against Client Earth, and Shell's supposed costs were pretty massive considering it was a leave stage. I think in practice the order won't be nearly so high, but I mean it certainly is an expensive process, and Client Earth are very well funded in terms of NGOs, but even for them it's quite a brave thing. So I think it'll be a brave thing for someone else to attempt it, but I would hope that there will be opportunities, and we'll wait and see.
Thank you very much, Lord Canworth. Pete, I'd like to turn to you, because one of the things that we talked about was, and maybe alluding also to the previous panel when we talked about a case concerning D&O insurance. So a case that you've brought to my attention is that of the INEA case, and I was wondering if you would like to share some of your thoughts and reflections on this case. Thank you.
Thank you, Jolene, and wonderful to be here. So this is a new case and responds, as Jolene mentioned, to one of the questions that was posed in the earlier panel about is there another case that focuses on directors and focuses on D&O insurers? And there is. It's a recent and little-known case called INEA and Kowalik that comes out of Poland. INEA is a major energy company suing its former board of directors for 650 million zloty, which is more than 160 million US dollars, in approving a coal power plant project in 2018 that was abandoned 2 years later. And in effect, I would argue this is a case about mismanagement of climate-related financial risk. I'll give some background. There are two chapters in this story and two cases, and I was closely involved in the first. It was my first case as a budding climate litigator 6 years ago. Both cases center around a coal plant called Ostrołęka C that was to be built in northeast Poland. It was a major project. It was a 1.2 billion euro project. It would have emitted up to 6 million tons of CO2 per year. Interesting for present purposes, I think, is that it was facing a number of very significant climate-related financial risks. EU carbon prices were increasing. The project would have faced competition from ever cheaper renewables. The EU energy regulatory framework was tightening, and banks were very reluctant to finance new coal projects, so it was having significant difficulties attracting investment. Client Earth, which has a foundation and team in Poland, purchased shares in INEA, this company, and sent legal letters to the board of directors arguing that were it to continue to invest in the project, it would be in breach of its fiduciary duties in mismanaging the financial risks that I set out earlier. The company decided to proceed with the project, and Client Earth then sued, arguing that corporate consent for the project was invalid. This first case wasn't a director's duties case as such, although it did argue that the consent to proceed with the project would harm the economic interests of the company. The court ultimately upheld the claim on a technical ground and invalidated the corporate consent. Interestingly, in terms of shareholder value, as it was reported in the Financial Times that day, the share price went up 3.5% on announcement of the judgment. So it was a case that created rather than destroyed shareholder value. Ultimately, the project was abandoned in 2021, and the investment was written down to zero. So an interesting case, but not a director's duties case itself. Chapter 2 of the story is where it gets interesting. In 2021, Poland's Supreme Audit Office conducted an investigation and found that the then directors of the company had mismanaged the relevant risks and recommended that the company take legal action against its former directors. The company, Inea, then commissioned legal advice. This found that the directors had failed to exercise due diligence and were liable to the company as a result. In December 2023, the company sued its former directors to recover the $160 million that the company had lost because of the decision to invest. It proceeded only against those directors who had voted in favor of the investment in this case. And it also sued the D&O insurers. In January, the following month, 87% of the shareholders voting in an extraordinary general meeting approved the company's filing of the lawsuit. And the argument, as it's previewed in the company's corporate disclosures, is essentially that the company had mismanaged the climate-related financial risks I alluded to earlier. This second case, I think, is particularly interesting because, unlike the first, it's not NGO-driven. It's a commercially driven case. It evidences that climate risk is properly understood as business and legal risk, and the case is a good illustration of how those risks can crystallize. Two final points that I think make this case very interesting. One is that the legal advice also noted that if the company's current board didn't issue proceedings against the former board, there was a risk that the existing board might itself be in breach of its fiduciary obligations. The second interesting point is that the case was brought on the eve of the limitation period, which, when one thinks about the limitation periods for claims of this type, stretching out to, say, 2030, I think offers an interesting temporal dimension of these sorts of claims, because the world is going to look very different then, as in this case, risks which were understood and acknowledged at the time, as I think most climate risks would be understood and acknowledged today, can lead to these sorts of destructions in value and provide a trigger for litigation. So one to watch, I think, in terms of perhaps filling this gap for directors' duties claims and directors' duties claims involving D&O insurers.
Thank you very much, Pete. So one of the aims of this panel is also to kind of bring attention to the wide, the big universe of climate litigation cases. I mean, I know that Joanne has mentioned previously that 70% of the cases are against states, and much smaller number is against companies. But I do think that one of the things that this panel, I hope, will be able to share is that there are many cases beyond the usual suspects, and this is one of them. It's a very interesting case that barely anyone outside Europe has actually considered or talked about. And I think the one point you did raise, which was really interesting, is that this case, given that it's not NGO-driven, which is what majority of litigation tends to be, highlights I guess one of the central messages of the earlier discussions about how climate change shouldn't be seen as a collateral or a side issue or an ethical issue for businesses, but a business risk to be considered. So thank you very much for that. And I now would like to invite Rajiv to speak about this from the perspective of the boardroom. So climate litigation is intended to have a signaling effect, particularly to those who are making the decisions for the business, and those in the boardroom about climate risk and all the failure to take climate risk seriously. So my question to you is, what do you think is happening with directors? Are directors being put on notice by climate lawsuits? And what do you think? How are they responding?
Thanks, Jolene. First of all, thank you for having me in this session. It's really been quite interesting talking to colleagues involved in these issues, and learning about these cases is quite scary. So, I mean, I guess that's to your question about how our directors are responding. I can share with you the perspective of boards in this part of the world, especially in India, which most of my business kind of work has been focused on India. So I'll talk a little bit more about that, but also my observations about board reactions in the rest of Asia. So one of the things that I've been preoccupied with at SMU is trying to better understand the drivers or the levers that really induce substantive behavioral change at the board level. And we were talking about this earlier, and part of my board advisory work has been very frustrating, to tell you the truth. And that's because, I mean, it's human nature. The self-perception of most people on boards that you talk to is they're doing the right thing. And so to advise them or to change their perspective on themselves is extremely hard, which is presumably why people have turned to more adversarial avenues for changing this dynamic, and that's where litigation comes in, and that's where regulation comes in as well. And my own experience is that litigation, so adversarial mechanisms can have unintended consequences. And let me explain, and how constructive they end up being depends on the context in which the business is operating and the culture of that environment. And it goes fundamentally to levels of trust. So let me just give you a couple of examples. In the case of India, there has been traditionally a cultural, historical, sociological distrust of business, especially within government. So if you are a regulator or you are a lawmaker or you are a civil servant, the general presumption in dealing with business is that you're a crook. And I need to do what I can to, stop you playing games. So it starts from a fundamental premise of I can't trust you. And business have this sense of defensiveness, therefore, in which they operate. This distrust of business has been is broad-based in a societal context as well. And so you see now, especially with climate change, great activism, social activism, which is now translating into legal action. And India is really quite an interesting case because we have a dysfunctional judicial system, totally overburdened. And litigating anything in court is a very long, drawn-out process. Partly for this and other reasons, the Supreme Court of India, some decades ago, opened up a public interest litigation window with the idea of democratizing societal access to higher courts. And that's led to judicial activism on a range of things. So, you could argue that the Indian judiciary has become a positive force for inducing social and behavioral change. Now, translate this to climate and environment. And what's happened is that judges in the Supreme Court, in the higher courts, have generally been empathetic to the concerns of aggrieved individuals and civil society organizations. And the right to a healthy environment has become recognized as a basic fundamental right. And what this means is that, and much of this litigation, to your point, has been against government, not against particular corporates, but it's been against governments. So over time, interestingly enough, the courts have compelled government to actually introduce climate-related legislation when there was none. So environmental laws have actually become more profligate, if you like, more invasive, more intrusive, and generally, more robust over time because of this public interest litigation. And that has made, is forcing corporates in India and boards in India to take more interest in these matters. And so you now have a national green tribunal in India, which over the years has developed quite a body of jurisprudence, which, going back to this cultural phenomenon that I was talking about, the lack of trust, can actually be quite penalizing for corporates. And so I would like to believe that corporates have become more attentive and are certainly concerned about the risk of this kind of litigation. But the unintended consequence of this adversarial dynamic is that it actually leads to, how should I put it? I guess it's a compliance mindset. So it's an attempt at the board level, in my personal experience. I hope I'm wrong, but this is my personal experience. The behavioral response is to find ways to prevent litigation through compliance kind of measures. There is no fundamental change yet in integrating climate issues as a much more serious business concern. Forget about business responsibility to the community. It's the second best or third best alternative. Is it producing the right kind of behavioral change in the boardrooms? I'm not sure, but it is forcing people in boardrooms to take this more seriously. I think over time, as regulations continue to develop, as international precedents, more international precedents are set, and as business risks actually become much more real, you will eventually see some change. Not quite yet. Last point I might like to make, and this is a sort of anecdotal basis on anecdotal encounters with people in Singapore. This thing about what I was talking about, trust. The behavioral response in Singapore, which is a society that has great trust in government, right, is very different. So, I mean, there are so many panels and sessions we've had with business on this topic. And what I find remarkable in conversations is how responsive business here are to, slight signaling from regulators. And this is particularly the case in my experience in financial services, where the MAS is quite a unique and very active central bank. So it's not just content to worry about foreign policy, inflation targeting and all of that. It actually takes upon itself a quasi-developmental role, especially when it comes to climate. And this is having, I would like to, from my observation, quite a constructive impact on finance industry in a country like Singapore, whereas I suspect that same dynamic would be almost impossible to replicate in a country like India, or for that matter, in the Philippines or Indonesia.
That's really interesting. And I would like to, I think from what you've commented, and there are two things that really strike me as really interesting to link to the bigger discussion that we've had. One is about trying to induce deep cultural and behavioral change in the boardroom. And in the earlier panel, we also talked about sort of the limits of disclosure, where it becomes a exercise in box ticking. And it seems like there is also that risk when it comes to litigation, where litigation proofing, it becomes all about compliance just to avoid litigation. And wondering, and I think the bigger question for us to all grapple with is, how then do we go beyond that, right? And also, yeah, the observation you made about the difference in how businesses respond to signals from policymakers is also a broader point about how it's really jurisdiction and country specific, how we assess corporate climate accountability and what are the drivers and levers that we could possibly tap on. So thank you very much for that. I would like to actually now invite Sean to actually comment and to pick up from what Rajiv has talked about. So Rajiv has talked about, you know, climate litigation and its impact in India, and touching a little bit on the regulatory context in Singapore. Now, in your view, what does it look like in the rest of Asia? Corporate climate litigation, has it been, you know, emerging? If not, why? So I'd love to hear your thoughts. Thank you.
Thanks, Jolene. And may I just say, it's surreal to be on this panel with my former boss at Client Earth and my current boss at Absol, and be surrounded by people who I've read their work and been very respectful of, and it's great. So enough of my fanboy moment, but crack on with the question. So I think the picture in Asia is complex, right, to say the least. It's not pulling in any single one direction. And I think, as Joanna mentioned, most of the cases around the world have, till today, been primarily targeted at governments, right? So if you think about the remainder, 30% odd of cases that could very well be targeted at individuals and corporates, vast majority will still be, you know, instituted in the global north, right? So Asia still is at a point in time of its climate litigation journey where still relatively nascent, right? But there have been certain notable developments in climate litigation simpliciter over the last few decades, which I think are worth pointing out to tell you where we've been, right, in as a region, and then where we are today, because I think there have been some notable cases which have happened in 2024 alone, and what I think that spells for the future and what needs to happen if we are going to see climate litigation really pick up in this part of the world. So we think about places like India, right, which has very much had a tradition of climate or environmental litigation because of the presence of the environmental courts tribunals, which have given a lot of that facility, that infrastructure for these types of cases to be heard. South Asia is a place where a lot of rights-based approaches have been used. So it's not just India, it's Pakistan as well. And that has been evolving, right, over time. In India particularly, we've seen that right to life evolve and then to the right to a clean environment, as Rajiv has mentioned. And just earlier this year, that has now translated into the climate change context with a case, I think it's called Westin and Union of India, one of the most seminal cases in India regarding climate change, where that right to a clean environment has now been interpreted by the court as a right to be protected, right, against the adverse impacts of climate change. And so these developments show, right, that with the right starting point, you can see this evolution towards climate change protection. Now, what's happening in India is quite different from the rest of Asia, right? Not necessarily rights-based approaches, but you do see cases in places like Indonesia where an indirect approach is taken with the intention, whether explicitly or not, to protect the climate, right? So, for example, in Indonesia, you do have cases where the government, through the Ministry of Forestry and Natural Environment, has pursued cases against palm oil concession holders or timber companies as against their burning of peatland, right? Lying at the center of those cases is not necessarily climate change, but you'll know that whether explicitly acknowledged or whether implicitly regarded as a consequence will have positive climate impacts, right? So you have these sort of indirect pieces of litigation that ultimately have positive climate impacts. Now, where that has led till today is an environment or a landscape of climate litigation which doesn't seem as though we're ever going to get to a case, for example, like Uganda and Netherlands, or Millet Defensie and Shell. But there are a couple of cases this year which seem to be moving the needle a little bit about where climate litigation could be going in the context of Asia, even in societies which have been traditionally regarded as less litigious in nature, right? So there are two examples that I'll pull from. One is the recent case with respect to Korea, okay? Korea, generally also less litigious, but just earlier this year, just several months ago, a group of activists actually won a lawsuit that they commenced against the government of Korea for the fact that the government had breached its duty to protect the constitutional rights of future generations by virtue of the fact that they didn't have a concrete plan to implement their reduction targets between 2031 and 2049. So to be clear, the government had a Carbon Neutrality Act, and that had concrete targets which were set all the way to 2030, but nothing really set down for what would happen from 2031 to 2049, which is a big, long time. And in ruling that this would prejudice the constitutional rights of future generations, the government was found to have breached those duties, and in a rather first of its kind case, the Korean court ruled in favor of these youth activists, right? So that actually spells a change, maybe a sea change, right, in the way that courts would actually regard cases of this nature in the context of Asia. Where corporate climate litigation, which is a little bit more pertinent to the discussion today, comes up is that youth activists are starting to become a little bit more, well, active in the context of Asia. And the other case which seems to be directly relevant is in Japan, right? Japan, once again, less litigious. And the fact that you had this really interesting case led by youth activists, and there's about 16 of them, all under the age of 30, is really bucking the trend in some ways, because youth are generally, regarded as being less familiar with the litigation process, don't have the deep pockets which are associated with pursuing a litigation of this nature, but nevertheless are undertaking this really big lawsuit against 10 major thermal power companies in the Japanese energy sector, right? And this is, of course, on the basis of a civil code that they have there, but the idea there is that these youth activists are pursuing these 10 major thermal companies on the basis that they have collectively contributed massively to global emissions. I think if all these 10 thermal companies' emissions were put together as formed a country, they would be the 16th largest emitter, right? And essentially, this case is about them getting an injunction to reduce their emissions, and I believe it's 40% or 40% by 2035 and 65% by 2035, right? So that's a major step in corporate climate litigation in the context of Asia, in a place where even the Japanese themselves regard the country as being not non-litigious in nature. And so we're starting to see these shifts start to happen within this landscape. What it does mean for the future of litigation is that places which may not be traditionally litigious in nature could very well see a case being pursued. Where I do think, and I do agree with Rajiv, that ultimately these developments may very well be sporadic in nature, right? We may not see suddenly a mushrooming of cases all across Asia. But what we are seeing right now, which may very well facilitate, right, and create a more conducive environment for litigation, corporate climate litigation, is the rise of regulation, right? These pieces of regulation I would distinguish into three categories, and all have the potential to really accelerate a lot of these risks, right, for corporates. One is greenwashing regulation, right? Greenwashing regulation, I think we're going to cover that probably subsequently, but very quickly, there is a whole raft of regulation that's appearing in all across the world. Canada, US, UK, EU are all starting to come down really hard on greenwashing and the misleadingness of green claims, right? And through all those regulations, there will be even more specific guidances which are being issued now, which will then provide sector-specific guidance, because every sector is going to have different forms of green claims, and therefore the guidance cannot be, one size fits all. It's a far more bespoke approach, right, which they're recognizing is going to be needed. The other one is the rise of disclosure regulation, right? Disclosure regulation has been around, has been the talk of in these circles for quite some time, but you will see that rise in enforceability as well, right? So in the context of Singapore, for example, we do have disclosure regulation. I think that was probably discussed earlier this morning in the context of listing rules for listed companies. All on what we call comply or explain basis. Sometimes they're in the form of a guidance rather than punitive, sanction-worthy regulation. But that is also starting to see some amount of shift, right? And this is happening in EU a lot as well. So, for example, the CSRD is going to be a major source of compliance cost for a company like mine. Because, and for a lot of other companies that may not necessarily be headquartered within the EU, but because they have operations within the EU, will subsequently need to figure out, okay, how am I going to comply? What are the timelines for compliance with these things? All in a bid to try and avoid situations where you fall foul or fall below the standards required by these regulations, right? If you look at climate litigation against corporates worldwide, there actually has been an outsized number of cases which are against companies for misleading disclosures, whether it's misleading disclosures or inadequate disclosures, all on the basis of laws which may already have been in existence. So just imagine a case where now the laws for disclosure are going to be now put in place, right? The standard that companies need to adhere to and the ability for a claim to be pursued against them for falling foul of those standards could very well be different, right, in 3 to 5 years' time. And finally, the third development in terms of regulatory development, or hooks, as I would like to call it, could very well be the rise of climate change framework laws, right? Climate change framework laws, from a empirical point of view, could very well be seen as increasing compliance by companies, by countries to meet climate-related targets, right? There has been a lot of push, right, at the international level to see countries embed climate change framework laws into national legislation. The most recent example of this is actually Malaysia, right? Malaysia has been, over the course of this year, really worked hard on trying to embed a climate change framework law into statute. It's not done yet. It's going to probably be something that they have to pass into enact probably next year. But you will see, even in this part of the world, the rise of climate change framework laws that will try and, whether it is to introduce emissions trading schemes, whether it's to put a price on carbon, all of which will have implications for corporates as well. So obviously, what the implication for liability would be for a company will depend on the shape and form that these climate change framework laws take. But ultimately, they are going to foist certain responsibilities and duties on these corporates, all of which I think will raise the bar for corporates to actually meet these standards and may very well produce that environment that could lead to climate litigation being a tool that more and more claimants may turn to ensure corporate accountability.
Thank you, Sean. That was a very comprehensive response, far more comprehensive than I thought I was expecting. And I think you are therefore the right person to be teaching the undergraduate module on environmental law. Thank you. I think that what you've highlighted are some of the most interesting trends to be spotting in terms of regulatory developments that provide the pathways for corporate accountability, which of course litigation is only one pathway for achieving accountability. I want to pick up on the topic of greenwashing. And I've learned today that there's not just greenwashing, green hushing, green wishing, green lighting. So what I would like to do is actually first to invite Pete to unpack some of this terminology for us in terms of financial, in terms of corporate accountability. And also perhaps just because and also perhaps as a result of listening to what Sean was talking about in terms of the landscape of Singapore, it's interesting that in Justice Jeyaretnam's keynote speech this morning, he highlighted that if there is one area of law of climate action that the courts would be well placed to take action on, it would be on tackling climate misinformation and greenwashing. So I think it would be very appropriate for us to be learning more about greenwashing. So over to you, P.
Great, thank you, Jolene. I'm not going to attempt to unpack some of the terminology that was new to me earlier. I came across green shifting, green rinsing recently as well. So I'll stick with solid ground and begin with greenwashing. Greenwashing or climate washing, essentially false or misleading claims about the environmental or climate impacts of a company, a service, a product, or a financial security such as an equity or a bond. I thought that it was put well earlier today, nothing short of classic misrepresentation. It's a widespread problem. Michael Tang referred to a Competition and Markets Authority study that found that 40% of green claims made online globally could be misleading consumers. And I think it's important to approach this with that understanding of why greenwashing is such a concern. In the financial market context in particular, it threatens the proper allocation of capital. The best statement I've seen of this is from Tan Boon Jin, CEO of the Singapore Exchange Regulation Company, who said a few years ago, the estimated green investment needed in ASEAN alone is $200 billion per year till 2030. The stakes are high, making it critical for the market to have accurate climate information to drive decision making. The biggest threat to this right now is greenwashing. And it also leads to an uneven playing field because, of course, if you're a business that is investing in and planning for your transition, you can be put at a competitive disadvantage by another business claiming falsely to be doing the same. So I'll set out a few of the cases that illustrate how we're seeing this translate into climate litigation developments globally. And I'll give two sets of examples, one from the regulatory space, one set from the private litigation space. And I'll run quickly through the first. Last month, as we heard this morning, the Federal Court of Australia ordered a $12.9 million Australian dollar penalty against Vanguard for making misleading claims about ESG exclusionary screens. This followed enforcement from the Australian securities regulator. In April this year, the European Commission started regulatory action against 20 airlines for potentially misleading green claims. In a very interesting case, in 2023, the Deutsche Bank subsidiary DWS paid a US $19 million penalty to the US Securities and Exchange Commission, settling a claim that it misstated its ESG investment process. One of the most interesting aspects of this case that I saw is that DWS trawled through more than 2.5 million documents in its internal investigation into that case. So a sharp uptick on the regulatory side, and also an increase on the private litigation side, including, interestingly, in Asia. We heard earlier about the case against KLM, finding that its sustainability and offsetting claims were in breach of Dutch law. There have been claims filed in South Korea, for example, against an energy company in relation to CO2-free LNG claims, and a steel company for its carbon-neutral steel brand claims. There was an interesting case in Japan against the country's largest emitter in relation to advertising CO2-free fire. This was described as unscientific baloney by the claimant, according to the Asahi Shimbun English language newspaper, which I found a charming translation of whatever the terminology was in Japanese. So it's undoubtedly, we're seeing greenwashing driving corporate climate litigation and regulatory enforcement. We also heard this morning about green hushing. I don't want to add much to the rich discussion there. I would just give some quick thoughts from a legal perspective on that question. I think the first is that if companies are making fewer false or misleading claims about their environmental credentials, then great. if 40% of environmental claims are false, then let's stop making them. I think secondly, and more fundamentally, there's this point about green hushing for fear of legal liability. And again, I would argue that those concerns are probably overstated. Certain climate-related information will be required to be disclosed anyway. This is certainly the case, of course, under the strengthening mandatory disclosure regimes that we're seeing being introduced around the world. And in communicating those matters to shareholders, companies and boards should be taking care that those statements are true and not misleading. Companies make regulated information disclosures all the time. If a company can't disclose to its shareholders its plan for a transition for fear of shareholders suing them for being misled, then I would suspect that's probably a problem at the corporate governance or the decarbonisation strategy level rather than a green hushing problem. On the comments this morning about the role of the courts on disinformation, I mean, I don't have sort of too much to add other than I found them fascinating. I guess chiming with the international experience insofar as we've seen from that 70% success rate, courts have, I think, probably felt on more solid ground in relation to those claims, but it's an area on which I'd be very interested to hear from fellow panelists.
Thank you very much, Pete. That was very, very helpful. So what I would like, I'd like to actually invite Rajiv and Sean to share with us their experience in the business on how do you deal with the, first of all, the increasing focus on greenwashing by consumers, by your customers and your stakeholders, and also with the increasing volume of regulations in this space. So perhaps with Rajiv first and then Sean.
Yeah, I mean, it goes back to, so there are two aspects to this. One is an appreciation by managements and boards about the relevance of green labeling for business, so for positioning the product with consumers. So sensitivity to the stakeholder community that is consumers is driving the need for some sort of green labeling. And that can get quite creative. So it's ironic that on the one hand, businesses are seeing an opportunity to integrate climate considerations into business, but they are doing this in an inappropriate manner. So, you know, they are trading on people's expectations of you know, responsible consumption, circular consumption, and all of that, and cutting corners to project themselves as champions of those themes when they're actually not. So that's one aspect of this problem. The other aspect of the problem is what I was talking about earlier, which is really just a compliance culture. And it's the growing weight of regulations that boards are actually trying to catch up with. And so the typical thing that catches the board of directors' attention first and foremost is compliance risk. And there can be genuine cases of, you know, inadvertent mistakes where they're just not keeping up with the changing landscape and they haven't been attentive to it. So it's just a genuine infirmity in processes. But in both cases, I come back to, you know, the broader problem that I raised in my previous set of comments, which is translated to this question, is that greenwashing is really the manifestation of a perverse behavioral response. And it's a perverse behavioral response to mechanisms that people don't find aligned, I suppose, with their mundane day-to-day priorities. And so I don't have an answer. I mean, how do we induce this behavioral change? But I'm not sure, therefore, that more regulations and litigations to prevent greenwashing is going to get us to where we want to get.
Thank you, and I'd like to invite you, Sean.
Thanks, Jolene. So I'll start off with my anecdotal experience, which is that on a day-to-day basis, my job is to look at a communication that's going to be put out and wordsmith it in a way that does not have any risk of greenwashing. Okay? So whatever green claims that we're making, I look at that script, whether it's 100 words, whether it's 500 words, over and over again, to just try and think whether this could potentially be the subject of a greenwashing allegation, right? Having done that, knowing at the back of my mind that there is still a risk that we will be alleged as being a greenwasher, right? And that is unfortunately, and perhaps to build on Raj's point, the state that we're in greenwashing now. So I offered a slightly different view that having gone through this exercise, having known about greenwashing for several years now, having written about it, having known theoretically what it means, the way in which it is now being translated into practice may have gone a little bit too far now, right? It's not just because there is now a whole suite of regulation that's emerging all across the world that is trying to clamp down on this issue, which has in and of itself been very beneficial for companies like ours to show that this is a risk. This is a risk that we do need to think about. This is something that risk is now translated to justifying my role in the company, making sure that I try and guard the company against these sorts of risks. But at the end of the day, leading to a slightly fractured picture where we don't know where we stand, even if we do our best efforts to try and mitigate it, right? Because it's one thing to put out a communication without having any regard, right, for whether or not it's going to be true. But it's another thing to really be very careful before we put out the communication to try and avert all these risks and still be alleged to be greenwashing, right? And so I think and just to try and keep it short because I know we're running out of time, my main point is that I think we need to, as Roger say, it's not that, there's not enough regulation. I think by now that there might be enough. But it's the interpretation of the regulation. I think we do need to find a place where we move on from what is an ideological notion of what greenwashing is to a point where the regulations are actionable, are understandable, are transparent, right? So that corporates can then be led to conduct themselves in a manner that doesn't fall afoul of these regulations and would not lead to green hushing, because I think that is what is happening now because of the ambiguity with the regulation, because of the openness in which regulators are able to look at the regulation, right, and still look at a company and say, I think this sounds and feels like greenwashing, is not a situation that helps companies get to a point where they're meaningfully mitigating greenwashing risk, but are still able to put out what they are genuinely doing, right? So we do need, I think we are in a bit of an inflection point with greenwashing related regulation that we do need to re-examine and see where it is it's actually going.
Thank you very much, Sean. I have a follow-up question on that. So first you had mentioned that as greenwashing regulations develop, there will be the need to start having more sector-specific guidance, right? So one of the developments in other areas of environmental law, over decades has been self-regulation. So if the industry comes together and realizes that we are in peril because there are some really bad eggs and they are making it really bad and difficult for all of us, then first of all, I guess my question would be two-part. First, in your sector, is there a drive towards some kind of voluntary self-regulation on greenwashing, particularly because your sector is very visible, because it's a business that's visible to consumers? So that's one question. And secondly, if there isn't that momentum for that. Could you just share with us why? Because in other areas of environmental regulation, whether it's chemicals or cement shipping, etc., we see often that sort of, that kind of trajectory of travel.
Right. So in relation to self-regulation, okay. So with sector-specific guidance, I think that's coming out. Like UK has put out because I think they had an investigation against ASOS and a few other retailers last year, which then led to the Competition Markets Authority in the UK to then issue out sector-specific guidance on what greenwashing or green claims should be and what they should look like in the context of the retail sector. And so we've taken a lot of guidance from that. Whether the industry as a whole should come together, I mean, that is an open question, and that could very well be something that we start thinking about. I'm aware of certain initiatives in different aspects of the retail sector, because it's not just about, whether we actually start having more recyclable materials, but it's also about, what happens to microfibers, what happens to, can we actually use dead stock as materials? So there are different standards which could be, different aspects of the retail sector that we're all trying to sort of take a closer look at. And they could all well lead to different types of standards which form out from the industry, right? So I think it's important to realize that the picture is quite sophisticated. And in order to come up with a standard, it's going to require a lot of work, right? It's already complicated enough that we are subject to a lot of these regulations, and to reconcile all these different standards, which are all saying more or less the same thing but slightly different as well, to just ensure compliance is quite the challenge. So I don't think that we are probably at a point where we're going to get to a place where we are going to develop standards ourselves, but you can be sure that everyone out there is trying to do their best to ensure that they meet with these standards, while still not feeling as if they are, ashamed to put out what they're actually genuinely doing. Yeah.
Thank you very much. Lord Carnwath, I'd like to bring you into the conversation by asking you a controversial question. A criticism of climate litigation as a whole is that it is judicial overreach. Criticisms often also add that judges are not equipped to appreciate the complexities of climate science and to make polycentric decisions about climate policy. I was just wondering, in your experience, and drawing on your experience, how would you respond to these sort of arguments?
I think it's not really the right question with respect, because judges, certainly in my experience, I'm sure here, deal with all sorts of cases of all types. And many of them are very technical, and they're not subjects on which the judges are necessarily specialists. But I think this morning someone said of directors that it's not the knowledge, but the ability to ask the right questions, the skill to ask the right questions. And I think any competent judge should be able to deal with a technical case. Obviously, you need experts if there are expert issues to come up. And I'm sure the judges in this country, most countries, are able to deal with different types of technical issues, and climate change is one of those. So I don't see that as a big problem. I mean, there is, against that, I mean, in a way, one might say of the Client Earth case, which I was critical of the judge. Now, it wasn't any lack of skill on his part. He's a very competent judge. But I think, interestingly enough, in the UK context, we have a division, in a way, between what we call the King's Bench Division now, which deals with sort of general cases, but in particular has an administrative court which deals with public law cases. And judges of that court would probably deal with quite a lot of cases which have climate change issues or environmental issues coming up, whereas the company case went to what used to be called the Chancery Division. It's now called something else, but it's basically a judge who would have come back from a much more technical, sort of financial and company law background, and probably had never seen a case of this sort of type. And so I think to some extent there's a sort of culture. I mean, if I'd been sitting on that case, I'd have grabbed it, because I love to decide a case of that sort. Whereas I suspect he thought, oh God, what are we going to do with this case? But I think his sense would have been, with this is bringing the courts into an issue which really nothing to do with them, which should be left to the directors. So I think there's probably different attitudes. And certainly one of the things we've been trying to do, I've been involved with the United Nations Environment Programme for many years, of trying to improve training of judges on environmental matters, is getting a sort of culture out there where people take these cases seriously. But I don't think it's a matter of judicial skill. The judge has got to be competent to deal with any sort of case that comes in front of him.
Thank you, Lord Carnwath. It comes down to competence. Thank you very much. I really appreciate that response. I think no panel on corporate climate accountability can can leave the stage without dealing with this very small subset of cases known as the polluter pays cases. So these polluter pay cases, of which there are currently two well-known ones, they seek to hold companies accountable for climate-related harm allegedly caused by their contributions to greenhouse gas emissions. I want to direct this question to Joanna. I would like to ask you, what do you think are some of the key legal challenges in these cases? One issue that often is identified as a stumbling block is proving causation. So I just wanted to hear some of your thoughts on this.
Sure. So the first point I would make is that we have now, since 2015, what we call the second wave of these polluters pays cases. We have around 30 of such cases that are all still ongoing. So it's hard to tell what's going to happen to these, but it's true that they are already very different from the first wave, which basically pre-2015, they were thrown out of courts very quickly because courts would say something like, we can't look into this, too complicated, scientific stuff, not for us. So that's changed. Since 2015, we haven't seen that happening anymore. So courts, even if initially there was some decision like this, let's even think about the Peruvian case in Germany, then the court accepted and the case went all the way to the judges taking a flight from Germany to Peru to examine the glacier and Huaraz. So we don't have a successful compensation claim yet, but what we see is that the science has I was going to say the science has evolved, but I think it's not exactly that. Yes, it has evolved, but most importantly, the science became better understood by lawyers, and the scientists and the lawyers have been talking in collaborative ways so that the lawyers can translate what the science has done. And there's a super interesting paper, a collaboration between legal scholars and Freddy Otto and others involved in attribution science. And basically what they notice is that they look at all the evidence that has been brought in these compensation claims, and they say that, yeah, they did bring some of the science that has been produced, but most of them didn't even engage with the state of the art of where attribution science is. So in the issue of causation, to what you asked, attribution science has been better understood, is better used. It is not yet state of the art, but there is, for instance, again, mentioning Freddy Otto's work, they have this initiative called WWA World Weather Attribution. And what it does is it responds immediately in the aftermath of a severe weather event. It will respond immediately to say whether that additional severity of the event can be attributed to man-made climate change. So with something like that, you can immediately after Hurricane Milton or the latest environmental climate disaster, you can have potentially evidence for a case. You combine that with the Rick Heady study of all the historical emissions, there is at least a case. So this is with the compensation claims, but of course not all polluters pays are this type, and if we have time, I'm happy to speak also a bit about the Brazilian cases which seek compensation for climate damage.
Thank you very much, Jana.